Hi everyone, and welcome again to Law and Society. Now, for this particular session, we are looking at the first theoretical perspective in one of many that you're going to learn in this particular subject. So, for this particular topic, we are looking at natural law as a theoretical perspective. But before we get into the subject matter, as usual, now, in previous lessons, we looked at a number of important concepts. The first we looked at was to try to identify what is law. If you recall, what we learned from this particular lesson was that law is a very difficult concept to both define or describe. Law means different things to different people at different points in time. And we learned that there were different perspectives about the law. We learned that law could be viewed from a positivistic view. We learned that law could be viewed from a socio-legal perspective. We learned that law could be viewed from a sociological perspective. In this particular lesson for this week, we're actually going to encounter one specific perspective of law. Other than that, we have also looked at the functions of law. Here, we took Wegel's identification of the functions of law as being social control, dispute resolution, and social change. In this lesson, we learned that the functions of law also are subject to how society has evolved, how society has changed. The law performs a very important function in society, but it's not the only function of control in society. It's not the only mechanism for dispute resolution. And lastly, we learned that although law can be responsible for social change, sometimes it is society that changes law. So for today, we're going to discover a theoretical perspective behind the law. We try to make sense of what the law is or what the law ought to be. As you can see, there can be a fundamental distinction between what the law is and what the law ought to be. In trying to find out what the law is, some philosophical perspectives endeavor to look at law as it is, while other philosophical perspectives try to look at the philosophical aspirations or aspirational goals of what the law ought to be. Is there a difference? Well, this particular lesson and the one that comes later on in Lecture 5 help us to try and understand the distinction between this is and ought debate. In this lesson, we also cover some historical perspectives about understanding the law. There are complex ideas involved, and it's your first exposure to some of these complex ideas, and we hope that you will make sense of some of these complex ideas. The lesson also teaches us an appreciation of the power of words. How words in this particular module make a difference as to understanding, as to concepts, as to perspectives, or even views. So let's get started with our lecture outline for this particular topic. Today, we are actually going to explore natural law. It is a theoretical perspective that attempts to help us understand about the law. It tries to provide a perspective as to grappling with the concept of law. Please bear in mind that it's your first theoretical perspective, and please bear in mind that within the concept of natural law, we are actually going to discover a number of variations as the evolution of society progressed through time. So we actually begin with classical natural law. In this particular area, we look at a number of classical interpretations of law through the natural law perspective. We learn about the decline of natural law, and we learn about its re-emergence. We then try and appreciate how natural law fits in today's modern society. And then we try and draw some conclusions. In this particular audio file, there are two segments, Lecture 4A and 4B. Let's begin with Lecture 4A. In trying to understand the natural law perspective, we need to understand that this particular area of law involves an analysis of theoretical perspectives. It is important to understand that the concept and function of law, i.e., what it does and what it is, depends very much on your own theoretical perspective. You will find in this course that you will encounter multiple theoretical perspectives. And it is common that the first time a perspective is introduced to you, it would appeal to you. It would make sense to you. And at times you will find that you disagree with that theoretical perspective. But whatever your views are, just understand that our purpose is to introduce you to these theoretical perspectives. And understand that these theoretical perspectives attempt to try to understand the complex concept of what law is. And because they are theoretical perspectives, theories like colored glass will depend on the color of your glass. What this means is the lens in which you view these theoretical perspectives ultimately depends on your own background. What influences your thinking? What influences your perspective? Whether it is your cultural background, whether it is your gender, whether it is other aspects of your life, these aspects sometimes will shape how you view a particular theoretical perspective. And as we've discussed in class, the fact of the matter is, because of the fact that every individual may have a different background and may bring to the discussion a different perspective on account of their background, it adds to the richness of the subject. It means that there can be variations as to thoughts, views, and perspectives. In this particular course, we will be looking at various theoretical perspectives. But we are going to focus on a number of key perspectives. These are not the only ones, but on account of time and space, we are limited to just covering the few that are mentioned here. We cover natural law, legal positivism, sociological theories, and socio-legal theories. The caution that we want to highlight to you is that some of these theories tend to overlap. This is because there are different ways to categorize theories. Some may come under sociological, and some under socio-legal, for example, or some may come under some prominent philosopher or theorist's name, for example, Karl Marx or Weber. A further point to note is that categorization of theories also depends on trends and perspectives. What this means is that natural law is a perspective to try to help us understand the nature of law or the concept of law. But this perspective is also subject to how society changes over time and over space. So at certain times in history, natural law was a very popular philosophical view, especially during classical periods. However, historically, later, natural law declined, and another philosophical perspective or theoretical perspective became popular, became more focused, and that was legal positivism. During the Industrial Revolution, social and economic trends influenced scholars, and so you have an economic perspective of law developed by Karl Marx. So the point is this: as societies evolved and changed, so too did the philosophical approaches or views or perspectives of law. And we see that even today. As modern society evolves, as the world changes, perspectives of law can change. There may be, for example, a lot of dissatisfaction with the capitalist system in place in many countries and societies. And there may be a move back to a socialist perspective. These trends are important to help us understand how people view law. Another point to note is that in modern societies, it is quite common to find a heterogeneous, urbanized, and modernized society. Contemporary societies, therefore, are made up of different ethnic groups, different gender perspectives, different socio-legal perspectives, sociological perspectives, different socio-cultural, socio-religious perspectives. Historically, most societies were homogeneous, small, with kinship and shared common values. So if you look back in time and space, it was common to find that countries were made up primarily, or societies were made up primarily, of a mono-ethnic group with a shared sense of common values. But as people moved, as people could travel, and as society evolved, societies began to be more heterogeneous, mixed, and more modernized. And this, as we recall in Lecture 2, meant that you needed a more complex legal system to maintain social order. Laws have to keep up with the complexities found in society, economy, and politics. So today, for example, when we talk about contracts, it is common for contracts today to be more electronic in nature. Financial services function more on an electronic platform than it does in traditional banking fields. This indicates that the law that we have has to keep up with these complex changes in society. Similarly, theoretical perspectives of law have also been evolving and changing. And this is an important point for this particular topic this week. So in early Greek civilization, for example, law was seen as absolute and autonomous. It was not related to the structure and function of society. The concept of natural law has its origins from this type of understanding. The law was considered to be far away from society. The law functioned in a way that was far away from society. Today we begin with natural laws. When looking at the word natural, there are many meanings that can be attributed to the word natural. So what is natural law? As we recall in the very beginning of this subject, like law, defining natural law is also complicated and difficult. primarily because there is no fixed singular meaning. In other words, the meaning attributed to the phrase natural law has evolved with time and with the corresponding changing in society. So changes in society and its views would mean that what we perceive or understand to be natural law would change. However, there is a core principle that we can attribute to natural law. And this core principle is stated here. Thus, the main assertion of natural law is that there are clear, objective, moral principles which depend on the nature of the universe, and these moral principles can be discovered by man's innate ability to reason. It sounds very complex, but what it means is that natural law proponents believe that the law can be identified because of our ability to understand and to reason. Because man has the capacity to think and to reason, then man would know that according to the nature of the universe, there are certain clear objective principles, and based on these clear objective principles, we would know therefore what is good law and what is bad law. We would know therefore what laws are applicable to us as human beings, because we have the capacity to rationalize and to think. Another important point to note is that because we are looking at the nature of the universe, natural law perspectives suggest that these are universal and immutable principles. They are therefore unchanging, irrespective of time and space. We will assess whether this statement is accurate or true. Now, early natural law concepts were derived from religious or spiritual beliefs, and in some cases even supernatural beliefs of the divine. So the origins of natural law comes from the time of the ancient Greek philosophers like Aristotle. Law was seen to be free from all passion and based solely on reason. And remember, many of these natural law theories derived from some connection with God. And the view is that because we are created by God, therefore we are rational beings, and this in a sense separates us from animals. The argument being that human beings are capable of reasoning and rationalizing, which animals, it is argued, are not. And because we are able to rationalize and behave in a way that we understand what our purpose in life is, therefore natural law was part of human nature. And human beings, being rational, who lived according to the laws of God, would be able to understand and discern what is inherently good. This form of law is said to be superior to any other and should be the basis of all legal order because it is said to derive from divine origins. We begin our discussion on classical natural law by looking at an ancient Greek philosopher called Plato. Plato is considered among the most important thinkers in the natural law tradition. Plato's dialogues contain extensive discussions of what is natural and what is according to nature, and how we should think about these things in relation to political and legal institutions and to the conduct of life generally. The suggestion here is that man should behave according to nature and what nature intended and what is natural to his being. As such, politics and legal institutions should endeavor to follow what is according to nature and what is natural. From Plato's perspective of man living his life according to nature and according to what is natural, we move on to another classical natural law philosopher, Aristotle. Aristotle is considered by many to be the father of natural law. Aristotle considered that it was natural for man to be a member of a polis, that man was social, political, and sought knowledge. Therefore, it was natural for man to be part of a system or a society consisting of other individuals. So, a metropolis, for example, draws its origins from this concept. So, if it is natural for man to be part of a larger group of society, and that man was social, political, and sought knowledge, then, according to Aristotle, this was man's telos, or man's goal or purpose in life in accordance with his nature. Therefore, for Aristotle, the nature of man, what is considered to be inherent in him, natural to him, or the nature of his surroundings being the basis in which ideas of law and state exist. So if it is natural for man to function in a society, then it is natural for there to be laws to govern that relationship between each other in that society. If it is natural for man to quest for social and political life, to seek knowledge, then there must be laws that govern these ideals. And because it is man's goal or purpose in life, then therefore these are inherently good things, because this is natural to man. So let's pause to think about some of these concepts. Man has the ability to reason, and the laws of nature are discernible by human reason. Thus, humans are morally obliged to use their reasoning to discern what the law is and then to act in conformity with them. For example, man has a natural inclination to eat, drink, sleep, and procreate. These actions accord with the natural law for man's survival. So therefore, it is within the nature of man to live life, to enjoy life, to eat, to drink, to sleep, to procreate, to function in a society. It is natural in man because he has the capacity to reason and know what is good for him. And because he knows what is good for him, then laws and societies must function in such a way as to promote what is natural to man. Conversely, activities that work against that law are morally wrong. So let's look at something very basic here. Let's look at procreate. If we apply the reasoning that has been taken by people like Plato and others, then it is natural for man to procreate. The view being that because God created man, then man must procreate because that is what God intended, that man would reproduce and produce the next generation and the next generation and the next generation. And because procreation is seen as being value to man, natural to man, in fact, when God created man, the argument being that that was his purpose, that man would procreate and man would create other beings who would then continuously worship the Creator. Animals procreate, plants procreate. So there is that system that is natural to man, that man must procreate. So if you have a law that allows for abortion, then would that law infringe this classical natural law perspective? Abortion would be said to be contradicting the idea that what is natural to man is to produce more kids, to reproduce, to produce the next generation. And therefore, arguably, from a classical natural law perspective, abortion would be contradicting that value. If life is inherent in man, and the right to live is inherent to man because it is such that man's nature is to survive and to live, then abortion would be contradicting that too. So too would be a concept like euthanasia, because euthanasia would be a concept that is contradicting the notion that it is inherent in man to live. It is not inherent in man to die. Because man functions, his reasoning would tell him that he needs to live to survive. And because man's instinct is to survive, then euthanasia perhaps would be contradicting this particular value. So classical natural law thinking based on the nature of man, what is natural to man, or based on the nature of his surroundings, formed the basis of philosophical thinking in viewing the law, the state, and the government. What about homosexuality, for example? If you have a law that allows for homosexual relationships, would that be contradicting the natural law philosophy? Arguably, it would be, because one could argue that a homosexual relationship would not allow for procreation, which is what is said to be an inherent value within the nature of man. But this point can be debated. Perhaps one can argue that you don't need to have that act of procreation between two men. It is perhaps biologically impossible, but certainly through science, it is possible for two men to have an offspring. It is possible for two women to have an offspring. So as you can see, natural law philosophies made sense. They were dominant during a particular period in time. But as you can see, as societies evolved and thinking evolved and science evolved, some of the arguments that are used to justify a particular perspective may not necessarily hold true. By the time we reached the Roman Empire, the concept of the law of nature, which had undergone further transformation, had reached a stage where it was now equated with universal reason identifiable with God. What this means is that classical natural law theories that we saw, for example, were looking at the nature of man, what was within man, or the nature of his surroundings. But by the time we reached the Roman Empire, we had a divine connection. We had a connection with God. Look at what Cicero says. He defined natural law as right reason, and remember, this is what man has. Right reason in agreement with what? In agreement with nature. i.e., we apply our capacity to reason, to think, to rationalize, in accordance with what is natural around us, or what is natural within us. And from this, we can derive the concept of one eternal, unchangeable law, which will be valid for all nations, for all times. One master, one ruler, and that is God. The idea here is that law is universal. Why is law universal? Natural law, viewed from this perspective, law is universal because it is created by God. It is in agreement with nature. So consider these issues. Let's look at the crime of murder, for example. Is the law that prohibits murder universal? Can this be explained using Cicero's view? Well, if you look at most countries, if not all countries in the world, murder is considered a crime. In fact, arguably, such laws existed for a long time and therefore are said to be universal, unchangeable, immutable in time and space. Almost all societies at some point in time evolved to recognize that killing another person was going to be a crime. Therefore, a crime like murder and the punishment that follows when one kills another person is perhaps a good reflection or example or illustration of Cicero's view that law can be universal, can be unchanging, can be immutable, can be applied to any society at any point in time, any culture, and any period in time. Murder is universal, unchanging, immutable because it is punished in the same way. Almost all societies will accept this. So we can see that Cicero's view makes sense when you look at some types of behavior which clearly indicate certain values. We value life because life comes from God, and therefore taking a life will result in some form of punishment. In Malaysia, if you took the life of someone away through murder, the punishment is by death. It applies the very old concept of an eye for an eye. But are there examples that you can think of where killing is not prohibited? So in Malaysia, as we said, if you murdered someone, then Section 302 of the Malaysian Penal Code makes it a capital offence and therefore punishable by death. So when we take away the life of a murderer and hang him, it is on the basis of a law that allows it. So as much as Cicero's view makes sense that murder is punishable, in some circumstances, killing another is not punished. So the courts and the legal system which punishes a person for murder by taking his or her life away as punishment, those officials are not punished because what you're doing is following the law. Another example, perhaps, is during times of war. During times of war, it is possible for one soldier to kill another soldier and not be charged for murder, although the rules on this are very complex. By the time we came to the Middle Ages, so we are looking at a historical development of natural law or classical natural law theories. We looked at Plato, we looked at others, we looked at Aristotle, Cicero. By the time we reached the 13th century, a very famous philosopher was St. Thomas Aquinas. Aquinas was known as someone who worked very hard at classifying various laws. What he did was to break down or analyze what he felt was the different types of laws that operate in a society. One of the categories of laws that he described was called lex naturae, or natural law. And he had this very important principle that he tried to put forth. He says if a human law is at variance in any particular with natural law, it is no longer legal, but rather a corruption of law. So look at that statement very carefully. It says, if a man-made law is at variance with natural law, such a law is no longer legal, but a corruption of law. What is important is a couple of important points. You can see that Aquinas makes the distinction between man-made law and divine or natural law. And in his view, divine or natural law is superior to law which is man-made. So he has a categorization of law in which he distinguishes between man-made law and natural law. And in his view, in the hierarchy of laws, divine law, natural law, is far superior to human law. The second thing is that if there is a man-made law which contradicts the divine law or natural law, the man-made law is, in Aquinas' view, no longer a valid law. This is summed up in this statement. An unjust law is not a law at all. In Aquinas' terms, he said, lex inuesta non est lex, which is a loose Latin translation of what you see here. An unjust law is not law. Lex inuesta non est lex. What do we understand by the statement above? The statement above suggests that all man-made laws are subject to a higher test. What is that higher test? All man-made laws must comply with divine law or natural law. How do we know, therefore, if a man-made law is unjust? Well, presumably it is unjust if it contradicts God's law or is against natural law. Who then decides if a law is unjust? Who decides that a law is no longer valid because it is unjust or not right or contradicts God's law? Think about these things. So, for example, if you have a law that allows for an abortion to happen, then applying the view taken here by St. Thomas Aquinas, then such a law would no longer be considered to be valid. A law that allows for an abortion to happen arguably would be contradicting the idea that God's law says that man must procreate. So a law that allows for an abortion or allows for abortions to happen, according to Aquinas, would not be a valid law because that law infringes a higher law. But is this really true? In a practical sense, one could argue that these laws are immoral or not right. But are they actually not legal? It's very difficult to argue that they are not legal because people still follow them. Similarly, if you have a law that allows for euthanasia, for example, applying Aquinas' view, would such a law be valid? Well, if taking away the life of someone contradicts the idea that God created man to live and not to die, then a law that allows euthanasia would not be valid, according to Aquinas. But how can this be so? How can a law that has been passed, how can a law that has gone through the process of being made law be considered no longer law? As bizarre as this view seems, as improbable as this view seems, it has been applied. In many circumstances, especially during World War II, we have discovered that Although, for example, German soldiers killed Jews, killed others as directed by Hitler and the government of Germany at that time. There were laws that allowed them to behave in a certain way. And even though they behaved in accordance with the law, what they did was said to be morally wrong. And eventually they were punished for crimes against humanity. And we will explore this part of that discussion in the next segment. So what have we discovered here? In the first segment, our purpose was to expose to you the different philosophical approaches to viewing natural law. So natural law is a particular perspective on trying to understand what is law. For natural law thinkers or philosophers, law means different things at different points in time. Early Greek philosophical thinking was to view law as being part of our human nature, and therefore what was valuable because we have the ability to reason, therefore we would know what is good for us. And by the time we reached the Roman period in time, natural law had taken on a religious view, especially if you viewed the thinking of people like Cicero and Aquinas. So from what is natural to man, what is inherent in man, from man's surroundings to what God has put in man, what has God created in man, natural law evolved and became a religious view on what law ought to be. The law ought to be good. The law ought to be just. The law ought to be in accordance with what God has decided. We'll stop here for now, and we meet again in a while for the next segment.